Hi, thank you guys so much for joining us today for our weekly Friday webinar. Today, I am joined by our awesome managing attorney, Ruby Powers, and we are so happy to bring you guys a new topic today. This seems to be the trend with PLG this month, rolling out these new topics. And today's topic is going to be on what are your immigration options if you enter the US without inspection? A very common questions that our attorney gets. So we want to just give you guys a little debrief on what the best solutions are or what our attorneys can offer. So a little bit on our managing attorney here. She has been licensed since 2008. She founded the firm in 2009. So the firm is a little bit over 12 years old. She is a board certified immigration attorney here in Texas, and she is also an author of Build and Manage Your Successful Immigration Law Practice Without Losing Your Mind. So she is a jack of all trades. And most recently, she founded Power Strategy Group, a consulting business. So thank you again, Ruby, for joining us today, and I'll let you take it away with the learning objectives.
All right, thank you so much. So we have, the reason why I wanted to do this topic is because there's just a lot of people have, they're in a predicament where they don't know what their options are, and they might have entered without inspection, otherwise might call it illegally, whatever, and without a parole inspection or things like that. And they're wondering, what are my options now? And so we wanted to, remind you the immigration system is very intricate and complicated. Sometimes, a lot of times we learn about things by stories and what my friend did this and I did that, and I know someone who did this. Well, it doesn't always work that way. Sometimes the law can completely change on a certain day. Everyone who did this before this day can get this, and the others who can't. In fact, in some cases, it's down to even the date, the time, on some of the citizen charts. Anyway, so really, it's important to have an experienced immigration attorney analyze your case, and that's really what this is all about. You want to make sure that the attorney is leaving no stone unturned, and they're screening, reviewing, considering all possible options. And so if hopefully this webinar will help you consider possibilities for your own case. Maybe you're eligible for something you didn't know about. And the other thing is that the immigration policy, procedures, memos, sometimes even the law are changing like all the time. So if you were told you weren't eligible for something in the last year or two, maybe you are, and you just didn't know it. So that's why I also say to get a consultation from an experienced immigration attorney, maybe get a couple, and make sure that you come prepared to that consultation with as much information, prior filings, prior Freedom of Information Act requests, what have you. So we put this presentation together from scratch, just from the perspective of, if you did not come in with inspection, would there be a way for you to stay here in the US and have a legal status, get work authorization, even be on the pathway to legal permanent residency and later citizenship? Yes, there are several options, including listed right here. I might have missed something, but I think this is a quite exhaustive list. So let's go ahead and get started. So adjustment, there's for getting legal permanent residency, there's adjustment of status, which is what happens inside the country. And there's consular processing, which is what happens outside in the consulate embassies, the post abroad. So if you can get your legal permanent residency or green card inside the country, everybody loves that. But not everybody's eligible to do it. So what are some possible ways? Well, this is an oldie but a goodie called 245I. And the gist of it is that you had to have an I-130, an I-140, or a labor certification, approvable when filed, at the time of before or on April 30th, 2001. And you're like, Ruby, that was like 20 plus years ago. Yes, it was. But the thing is that people still are able to use this provision. We just got a green card approved, I think, last month on this exact provision. Because if somebody, like let's say your parent had a petition that was filed and you were a minor and you qualify to be a dependent on that case, you could use it just for the provision of what we would maybe call like a legal entry. It's sort of the 245I waives the need of a legal entry if you meet this qualification and pay $1,000 fine, which in Spanish we call it the multa. And so then you could use that in effect like your legal entry, if you will. And if you worked illegally or you overstayed, and your visa available is not an immediate relative, it's okay. So let me just try to oversimplify it. If you have a petition, an I-130, an I-140, or labor cert, you or maybe you were underneath a petition that was filed for a parent, for example, by April 3, 2001, explore this option. Do not pass go. Do definitely double check this one before you move on to your options, because there are times when people are eligible for this and they do not know it, because what you could do is you could get your green card inside the country, not have to leave, not have to trigger any bars, and it's amazing. So the other possibility would be with DACA. Now, how would that work? Well, if a person entered with DACA, entered illegally without a status, without inspection, and there's a couple scenarios. One of them is that let's say they have a visa available and they do consular processing, and they want to they could do the provisional waiver, or if they got DACA before they turned 18 and started accruing unlawful presence, and they leave the country only while they have DACA to do consular processing, they won't need a waiver. We have cases like that. So if you got DACA before you started accruing unlawful presence at age 18 and you're married to a US citizen, for example, you could do consular processing and just leave, go to your home country for the appointment, not need a waiver if you don't have any other inadmissibility, and be able to get your legal permanent residency. The other possibility is if you apply for a travel permission, and which is based off on three things. One of them is humanitarian, which is like visiting a sick grandma, aunt, uncle, mom, dad. But the other one is school or work. If you can establish that, and you can get that permission, you can travel. Okay, if I'm going into detail, you have to have valid DACA, you have to have a valid passport, and then you have to apply for the permission. Then you have to get it, and then you have to travel and come back in. Now, when you get that entry, then you will have that legal entry. And if you later happen to be married to a US citizen, you could do your green card inside the country with adjustment of status. So this is where, and if you need more details, you can have a consultation. We can go into that. But this is where having DACA could open the door, either by not accruing unlawful presence or allowing you the travel permission for legal permanent residency. And right now, you cannot apply for new DACA, or if you do, it's pending. It's not going to be adjudicated or processed because of recent litigation, but you still can apply for travel permission. The last that we've explored this option. So another possibility is very similar to the DACA scenario is temporary protected status. And there's a lot of TPS for many different countries like listed here. And like Venezuela, Haiti, Nepal, Nicaragua, Syria, lots of different countries, right? So if a person had TPS, whenever you have TPS, you're not accruing unlawful presence, just like that whole DACA talk. But you also can apply for travel permission, and it's not as strict as the DACA travel permission. You don't have to prove it. It's because of humanitarian work or school. If you were to travel on this permission and come back in, then you would have a legal entry. And if you're married to a US citizen, for example, immediate relative, or you have a US citizen parent, then you could adjust. I mean, we have to look at all the other fine print, no crimes, no other illegal multiple entries, no deportations. But this is what an option that TPS could lead to that as a possibility. Now, the other one that's just, I think maybe it's a secret. I don't know. I don't want it to be a secret. That's why I'm telling you about it. It's the military parole in place. Now, the gist of it is, let's say a person entered without inspection, and then they are the spouse, widower, parent, son, or daughter of an active duty member of the U.S. Armed Forces, an individual in the selected reserve of the Ready Reserve, or a military veteran, as long as they were not dishonorably discharged, who served in active duty or in the selective service of the Ready Reserve. Now, if you meet any of that, all of that, one of those, and meet that qualification, then we could submit what an I-131 form to your local field office, and then they can respond with a parole. And that parole allows you to get work authorization for 1 year, and it's considered something that allows you to potentially adjust status inside the country if you have a visa immediately available, and we'd have to look at the situation, but in most cases when this happens, the individual is either married to a U.S. citizen or has a U.S. citizen 21 and up child, and then we are able to do their green card and adjustment of status inside the country. So this is another possible option, and a lot of people might not realize that this exists, but it's amazing, and definitely do it if you qualify. And we screen for this all the time. So the other thing to look for is the provisional waiver. And honestly, we do this a lot. We do this, and this is when, okay, let's see how to explain it really fast. This program came out in 2013. And before, if somebody entered illegally without inspection, they were married to a U.S. citizen or had a visa available, they had to leave the country. And as soon as they left, because of IRA's, okay, I won't tell you all that stuff, they triggered a bar. They needed to submit their waiver, and they'd have to file their waiver while they were outside of the country. Well, there was room for improvement suggestions, and under the Obama administration, they said, hey, this is crazy. All these people are having to be away from their kids, their spouse, their lives, their jobs. They're pillars in the community. Okay, what if their case is relatively squeaky clean, we'll let them submit the waiver here in the country. And then when they go abroad, they'll provisionally be approved that waiver if there's no other problem. And then they should hopefully only be out of the country for maybe a week, maybe 2 weeks. And so they're not gone very long. It's not a huge disruption. So this started in March 2013. Wow, I can't believe it's almost been 10 years. And then it expanded, and it's been amazing. A lot of people look at it and they're like, well, I still have to leave the country. Well, yeah, but not very long. So the scenario would be you have a visa available, and the visa becomes current, and then you submit a waiver. The waiver is only, you can only qualify for it if your only problem is unlawful presence, that you overstayed. It's usually that you entered illegally without inspection and you've overstayed, or you entered legally but you overstayed and you don't have an immediate relative. But anyway, we can talk about more in a consult. And then you submit the waiver, and the waiver, it says to the qualifying relative. So let's say it's a U.S. citizen spouse. This spouse cannot move to your country and cannot live without you. And we establish that, then we also submit the National Visa Center process. Long story short, you would get an appointment in your home country, and at that appointment, you do a medical exam, you answer some questions. If all is well and they find no other problems or blemishes and immiscibilities, then you're able to get your legal permanent residency, come back into the country, and your green card comes in the mail. Now, this whole process can take maybe 2 to 3 years. In fact, the I-601A form right now is taking 2 years. I can't believe it. It's taking 2 years, just the form adjudication itself. We're hoping to see a speed up in that. It used to only take 3 to 6 months in the past. But this program works, and people are so happy. And this is really the program that we use the most for when people enter without inspection and have a qualifying relationship with a U.S. citizen or legal permanent resident family member. Now, the other option is asylum. Now, this has a lot of restrictions to it, and it's not something to do lightly. You never want to file frivolously, but if you meet the qualifications, then you should definitely apply. Now, our firm has a lot of experience. In fact, our firm is attending the American Immigration Lawyers Association Asylum Conference this week because we are so adamant that we care about this topic and have many cases. In fact, we've helped individuals from more than 25 countries apply. So we're not just from one country or a region. we have helped people apply successfully from multiple regions and parts of the world. We've also gone to court in multiple cities and states and attended asylum interviews in multiple asylum offices, almost all of them, except for the California asylum office, it looks like. And so what is all that to be said? If you had experienced past persecution and or fear of future persecution on account of one of the 5 protected grounds, race, religion, nationality, membership in a particular social group, or political opinion, then and you apply within 1 year, there's some exceptions, you have nowhere else to go in the world, and you couldn't relocating in your country would not solve your problem, then this is an option for you to consider. And at our firm, we definitely review a statement and a consult and see if this would work. But if you enter without inspection, it doesn't matter. And as long as you're inside the US when you apply. Now, the other option that a lot of people might not know about is the victim of a crime. And this one is what's called the U visa. If you have suffered substantial mental or physical abuse while in the US and you're willing to assist law enforcement or government officials in the investigation or prosecution of the crime. So it has to be a qualifying criminal activity. For example, aggravated assault, like if it was assault with a deadly weapon, that's one of them. And there's a list of it. If you just Google qualifying crimes for U visa, you can see that. So it's not any crime, has to be pretty heinous. And if it's on the list, then the next thing is you want to get a visa certification. Now, from the police, you would, now some counties have a certain centralized system in which you would just send your request there and then they will sign or not sign, depending. There technically is no age to when the crime happened, but some certifying and designating police offices, they do not want to sign if the crime has been old. It's like more than 4 or 5 years, 6 years. So it depends on where you apply for this. But anyway, it's something to consider. And the other thing is there's only 10,000 visas available a year. So there's lots of people applied, and now the wait time has gotten considerably long. But at some point you are eligible to get work authorization. And if you get the visa approved, then you can also apply for your green card a few years later. And so this leads to a green card. A U visa is one that can waive many options, many blemishes and admissibilities, including entering without inspection. So this is one that is not really well known, but it definitely is an option. The other one is the T visa. And this one is if you were a victim of severe form of human trafficking, and you were able to prove that you're available for the investigation, prosecution of the trafficking, then you could apply for this. You also could include family members. And if you get the T visa, you're also eligible later for work authorization and a pathway to a green card. And a lot of people think of it as only sex trafficking, but it also could be other forms of labor trafficking. So it's if you are forced to do something against your will, your documents were withheld, you were told that you had no power to do certain things, this is something that you could explore. And there's a lot more options for the certifying, the group that can certify, including Department of Labor, can even certify the certification for the T visa. Now, the other option that we see more frequently as well is the Violence Against Women Act, VAWA, and you have to be a battered spouse, child, or parent to be able to apply. You do not have to be a woman, even though it's called Violence Against Women Act. You could also be a male or transgender or what have you. There's it's not specific to a certain gender. And in fact, we've had success with all different types of VAWA. And ultimately, the reason we listed this one is because you don't have to have entered legally to be able to qualify for this, and you can have a pathway to a green card. So if you want to learn more, just give us a call and we can go into more detail about this. Now, the other thing to talk about is cancellation of removal. Now, if someone were to be put in immigration court proceedings, one of the forms of relief that is a nice catch-all is called cancellation of removal. And there's for the non-legal permanent resident. And the gist of it is that you were here in the country at least 10 years before you were put in immigration proceedings and received the notice to appear, and that you also have extreme and unusual hardship to a U.S. citizen, legal permanent resident, spouse, parent, or child. And if you were to get this approved, then you can get legal permanent residency. And so this is a really great option, but you have to be put in immigration proceedings, and then you also have to be prove that standard, which can be very difficult to prove the standard that you meet the qualification of the extreme and unusual hardship. And when you talk about the 10 years that you have to prove, you have to show that with taxes, bank statements, other type of proof. It can't just be you say when you entered and then boom, you have your 10 years. So that is another great option for those who don't have inspection. The other thing to mention, it's not technically a form of relief, but I might be talking a lot of prosecutorial discretion a lot, but this is an option where the trial attorneys are allowed to work with you on stipulating, agreeing to certain elements of your case, and also about continuances and lots of other things. And they could also work with you to reopen court cases if you had an absentia order, or you have a deportation order and you have a better form of relief and you didn't have at the time. So this is just sort of like a nice little wild card that's making things better for immigrants. And a lot of this stems from the fact that immigration court has 1.3 million court cases. And by being able to allow the judges to terminate and administratively close, and the trial attorneys to work with the private, attorneys, or to the attorneys to be able to find some type of resolution that doesn't require the courts, is really helpful. And I think we're just begun to see the benefits of this recent memo. And then moving on to this is another thing that exists now. It's super long time ago, before I was even born. And I've only done one case like this. But I could tell you lots of immigration attorneys who've been practicing as long as me have never touched one like this, I could tell you, because it's sort of like a unicorn case. But it goes like this. If you've been here in the United States since January 1st, 1972, and you can prove that you've been here that whole time, then you just pretty much have to show the proof that you've been here and you can get a green card. I'm just oversimplifying it, but not so much, because it's pretty simple. And they're not very particular about lots of problems you might have had, if at all. So it's not that hard. The hard part is having to have been here that long, and not having already gotten into a status, because most people have already found some way to find a status. So the case that I had that was on point for this was the person thought he was a U.S. citizen, but he found out he wasn't. And then we used this provision because luckily he had a ton of proof. They had been here since then. So this is another possibility. But for 72, so then that's like 50, almost like 50 years that you'd have to be here without a status. And I think that makes the most sense. If a person probably thought they were a citizen and they didn't know it, that makes more sense, because most people who'd been here that long would have probably found a status. But the other one is Western Hemisphere priority date. Now there was a it goes like this. The Western Hemisphere priority date is a type of priority date that was part of a savings clause in a 1976 law that preserved the old priority dates of immigrants who qualified and registered for immigration before January 1st, 1977. So this one's newer than the last one I just talked about. As part of the savings clause, certain Western Hemisphere aliens are allowed, or immigrants are allowed early immigration. So the old priority date can be used when any properly approved visa petition filed by the alien, the immigrant, the new petition filed is deemed to have been filed on the previously obtained date. So bottom line, if anyone in your family, you or someone else had ever registered to immigrate or applied to immigrate before 1977, might want to consider this as a possibility, and then explore this. Maybe they could use an old priority date, and this could open up a lot of options. Now, this is the other wild, crazy thing. What if you're a US citizen and you didn't know it? It could happen. It could happen. It doesn't happen much, but it could happen. I mean, a good immigration attorney is always going to be considering, what if you're a possible citizen and you just don't know it? That's why in all our intake questions, we ask, do you have any U.S. citizen legal permanent resident family, especially parents, grandparents, because we want to explore that option. You might be a citizen different ways and you didn't know it. Maybe nobody knew you were, and they tried to do your paperwork and they messed up and they didn't realize you were really a citizen the whole time, because people can be a U.S. citizen and not have proof of it. Crazy, but true. So then in conclusion, hope you're staying with us here so far. A lot to take in, but hopefully it's been helpful to the audience. The best practices is just find a really good attorney that can help you. I mean, obviously we're biased, but let's just
just a little bit.
Yeah, just a little bit. But do your research, review their website, the state bar reviews, who you're going to have a consult with. Does the attorney have experience with similar type of cases as yours? To come prepared, just like you would go to a doctor or specialist and you have your list of questions. You've already gone to maybe a generalist. Have those questions so that you can pinpoint, get the most out of that consultation. And a good attorney will, if they don't know the answer, they'll generally say, I don't know, that's a good question, I'll look into that, and give you some options in the future as well. Bring relevant documents. That is so critical, because if somebody petitioned for you a long time ago, if you ever had a denial, if you have an A number, A numbers, definitely bring all of that to the table and make sure that you know how to communicate with the firm and understand the timeline. If you have a complicated case, if you want to make a timeline so that the attorney can just quickly assess the situation instead of you having to rehash the whole story, that also can be very helpful too, because an attorney can read faster than listening to the facts, and they would be able to be able to sort of see what they can do for you and to make the most out of that consult. So the biggest thing is you want to find somebody who's going to explore all options, paying attention to continue legal education, all the updates that are going on, and trying to find ways that they can better serve you and help you during this time. So hopefully your biggest takeaway is there are options. Maybe you or your family or loved one, somebody is eligible for them, and just need to screen. That means review, analyze, double check, look under every stone, figure out what you possibly are eligible for. So thanks so much, Dana. I'll let you take it away.
Of course. Well, thank you so much, Ruby, for all this information. Wow. Really, really jam-packed to this one. So we are really excited to share this information. And again, like we said, this month, we're trying to, to get new topics out. So if you guys have any topics or suggestions that you all would like for us to talk about, please do let us know. You can give us a call at 713-589-2085 or email us at contact@RubyPowersLaw. Our next webinar is going to be on immigration updates, asylum in the U.S. You can go ahead and put your phone up and register to that barcode right there, right? Innovation that excites. And again, we also do urge you guys to subscribe to our newsletter. It goes out bi-weekly, and we are sure to pack it up to the brim with immigration trends and updates or any policy changes that we feel are important to you and to anyone who is interested in immigration. But again, thank you all so much for joining us today. We hope to be a reliable source for all your immigration trends and updates. But thank you all and have a great rest of your day. Bye.
Thanks.